Hello, everybody, and good afternoon. My name is John P.L.L.C. I'm an I'm an estate litigation attorney with P.L.L.C. Hauser in downtown West Palm Beach, Florida. Our firm actually does not handle estate planning or any drafting of wills and trusts. We only handle disputes, trials, and appeals related to wills, trusts, estates, and related guardianship matters. So for the next hour, we're going to be speaking about ethics for Florida probate lawyers. This is a free webinar on this topic. And you'll be eligible for 1 credit hour for ethics or for general from the Florida Bar. So Florida Bar members, you'll get an hour for this. The course number will be announced at the end. It's on the last slide, and God knows we've got a lot of slides. We've got about 150 slides and a lot of materials to cover in the hour. Ethics for Florida probate lawyers, 1 credit. We at our firm offer a number of webinars for Florida Bar members. We just had a 2.5-hour ethics CLE that involved estate planning and related probate and trust malpractice issues for the probate lawyer, the estate planning lawyer in Florida. So most of our webinars are slanted towards or skewed towards the Florida estate planning attorney or probate practitioner, because those are the lawyers that we work with most at P.L.L.C. Hauser, because our practice is limited to trials, disputes, and appeals involving wills, trusts, and estates, and now guardianships. And I think every lawyer who handles probate matters in Florida has seen their guardianship practice be either begin or explode. If you asked me 10 years ago if I was going to handle guardianship cases, my answer would have been no, we don't do that. And now guardianship litigation is a very big and a very important part of our practice. So you're going to get an hour for today's credits on ethics. You'll also get an hour general. If you need additional ethics credits, you can call Amanda Phillips at P.L.L.C. Hauser Law Firm. Her extension is 101. Her direct line is 514-0900. We have a live audio and visual for that 2.5 hours on ethics and malpractice for the estate and probate lawyer. So if you need more ethics credits, call Amanda or give Amanda an email at amanda@phflorida.com. P like P.L.L.C., H like Harry or Hauser, Florida.com. So let's talk today for an hour on ethics for Florida probate lawyers. We've got a number of topics to cover, and you're probably asking yourself, why are we here today? And we're here today is, one of the reasons we're here today is to give you some perspective, right? We're going to give you some issues which our law firm, P.L.L.C. Hauser, faces, comes across, discusses, litigates, and handles appeals for. You know, we're litigators. We don't prepare estate plans. We don't write wills. We don't prepare trusts. And so we're usually in a situation where there's a problem, right? There's a lawyer who needs a hand. We defend and are often called upon to represent a number of lawyers, either as PR or in their role as attorney. And we have a very vigorous defense practice for personal representatives and trustees, and we also have a plaintiff's practice helping beneficiaries out there. And so some of the issues today, as we like to joke, are issues which give us heartburn, right? Us as litigators that we're challenged by. When we see things that we don't like or that we would do differently, that causes angst. And so we're going to be talking about some of those issues that we see. We're going to be discussing some recent cases, all in the backdrop of Florida ethics. So our discussion outline for today is we've got a huge introduction. We've got a lot to talk about. Throughout the course of the day, we're going to be talking about recent Florida cases. We're going to be talking about a number of very specific rules from the Florida Bar, rules regulating the Florida Bar. Some recent non-Florida cases. I've got a whole list for you if you're interested in what's happening in other areas of the country, mostly in the estate planning malpractice area. I've got a whole list of cases that were just handed down just in 2016. We're going to talk a little bit about estate planning and probate malpractice. We're going to talk about the cause of action, the interesting legal doctrine of judicial immunity. And we're going to talk about estate planning from my perspective that can cause the most angst for most of you listening. Most of you listening are estate planning attorneys. You're preparing wills and trusts. You're advising families and family members how to leave their wealth during life and at death. With the lifetime exemption being as high as it is, the focus for tax minimization becomes less important, and wealth administration becomes a little bit more important. And so you're often called upon to change a will, draft a codicil, maybe oversee a codicil being executed, or prepare a new will or a new trust or a trust amendment or a restatement of a trust. And I think one of the challenges for estate planning attorneys is many times you're called upon to make a change to someone's estate plan when they're on death's door, or they're sick, or their condition is worsening, and you're called upon sometimes to try to do things right away, and that presents a whole host of issues. But some of the estate planning cases or malpractice cases that we're going to discuss involve the will or trust that wasn't drafted fast enough, right? Where you say, somebody comes in and says, put Johnny in the will, he's not in the will, change my will, put Johnny in the will, and you just don't get around to drafting it fast enough or having it signed as quickly as possible, and the client passes away, and Johnny gets mad because he's not in the will. And then we'll conclude. So let's begin with our introduction. Let's start talking about these things. Let's talk about our ethical boundaries and our rules. And you see a picture of me and my law partner, Rob Hauser, with the City Hall dome in the background, and the Como building on Clematis Street in the background. That's actually our old office. We sold that office space, and we're moving to 415 South Olive Avenue in January of 2017. We'll be right behind the tower on Flagler Drive that houses such law firms as Jones Foster, Lou Marachik's firm, the FBI. So we're just a block away, and we're right just about on the corner of Fern and South Olive Avenue, just a short walk to the courthouse. And so we've got these boundaries, right? And we've got these boundaries because our conduct is highly regulated, right? Very, very regulated. None of us want to end up doing something wrong that makes us a defendant in a jury trial, right? And so we've got a balance trying to make a living and running a practice and practice management with our duties, which we are required to comply with, and our conduct, which we're required to control in favor of our clients. But, you know, as far as a backdrop that goes, you know, there appears to be an increased likelihood of litigation against estate planning and probate lawyers, right? And if you ask why, well, I'll give you 56 trillion reasons why. That's the figure that the Boston College Center of Wealth and Philanthropy uses when they describe the world's largest or most massive wealth shift in humankind. $56 trillion are being passed from the World War II generation down to other generations such as the baby boomers, Gen X, Gen Y, the millennials, and it seems that everyone's fighting over it. In fact, a 2008 Probate and Property article addressed that very issue, how estate planning attorneys and probate lawyers are increasingly the target, at least back then statistically. They were a very large category for malpractice claims in the legal profession. And so you have the probate wars, right? You have the probate wars, and lawyers aren't immune. In fact, we're right in the middle of it, right? And if you're administering estates out there, or you're helping to administer trusts, because many of you draft living trusts or revocable trusts, and oftentimes you're called upon to help out with the administration after the grantor dies, you're smack dab in the middle of these probate wars. And so the slide you see in front of me is the cover of a 2017 book that's expected to come out that I wrote. It's a work of fiction involving a number of short stories on the inheritance wars and the inheritance fights. The first slide that you saw was a slide of my trustees book. And if anyone would like a free copy of Pinkowski's Trustees Guide, please call or email Amanda at Pinkowski Hauser. She'd be happy to get a copy to you free of charge. The Trustees Guide is a great guidepost for beneficiaries as well as trustees. If you're a Florida bar member, I don't know that it's going to be very helpful to you. Although I've got to say that at least 2 law firms read it and then said that they found it quite appropriate for 2 trials that they were involved in, which is always flattering. And so because our conduct is regulated, we need to do the right thing for our clients, right? That's according to an oath that we took, and it's also according to our standards and our conduct, our rules that we agreed to abide by. So it's, you know, do the right thing just isn't a title. We have to do it every day and all day in practice. So let's start talking about some of the ethical rules and our basic duties. And everyone seems to think that that starts with the rule on competence, right? Rule 4-1.1, a lawyer shall provide competent representation to a client. It requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And case law would tell you that it doesn't end there. You need a certain degree of care, skill, and dispatch. And when I read dispatch, what that says to me is you've got to get stuff done in a reasonable time period. Look, all of us have been through a number of ethics CLEs before, and so you're probably sick of hearing about this rule of competence. But think about it from a different perspective, right? And that may be the dispatch perspective. You've got to get stuff done over in a reasonable time period, not necessarily in knee-jerk fashion, but you can't sit on your hands either. Why? Because our clients are depending on us, right? Their legal matter is in our laps, it's in our hands, and we've got to address it. And if we don't want to address it, we have a duty to tell our clients that, tell them to seek new counsel, and nonetheless protect them at all times until they do retain new counsel or we're discharged by a court, right? And a quick note on that from an ethical or potential legal malpractice case, we see a lot of lawyers, a lot of non-litigators who like to file notices of appearance, both in trials and in probate matters. Our firm's practice is not to file a notice of appearance unless we're actively involved in the case. We don't, you know, our business model or our practice model doesn't involve oversight. We never get into a case just to get copies of documents. We can get those online or at the courthouse. So be mindful of what you're filing in the court, and be mindful of what you're appearing in, because you're on the line and you're on the hook. And if things go wrong, I don't think a court is going to say you were there just to look at documents. So in the competence rule, you can look at that air turbine technology case. That was a 15 case where the court said, the fourth said, an attorney may be held liable for damages incurred by a client based on the attorney's failure to act with a reasonable degree of care, skill, and dispatch. That's the competence rule or the competency rule. And they cite a very important 1998 Florida Supreme Court case, Crosby v. James. The air turbine tech case, lot to learn from that. That was a highway to heartburn. That was one filled with angst. It started with this company that said, hey, I've been damaged, and I think I've been damaged to the tune of $20 to $50 million. And so this law firm takes on the case. They file a lawsuit. The clients offered $500,000, and they reject it. Now, unfortunately, it ends bad for the client. They lose at trial. There was a summary judgment loss. There was a motion for over $4 million in fees. $850,000 was sought in costs. And so the federal court rules one way, the appellate court rules another way, and Air Turbine sues their lawyers, and it goes up to the fourth on an appeal. Judge Brown was the trial judge on this malpractice case in West Palm Beach. And you talk about angst and heartburn. You had a federal case, you had a federal appeal, then you had a malpractice case, and then you had a malpractice appeal. So you have federal court, state court, and all of this, and the attorney's advice about legal fees was actually correct. For more detail about that, check out the Air Turbine Tech case. A long, highly litigated, very expensive case, no doubt. That's also a judgmental immunity case that you want to read. We're going to talk about judgmental immunity a little bit later when we talk about elements of the cause of action for legal malpractice or professional negligence and the defense of judgmental immunity and affirmative defenses. But hey, let me ask you out there, is there a concern about non-litigators litigating? Are you handling hearings? Here's what we see a lot. You heard me say a few minutes ago, that we, the trial lawyers who handle probate litigation at P.L.L.C. Hauser, we see a lot of probate lawyers, a lot of estate lawyers who do not litigate, right? They don't have any trials under their belt. They don't have any appellate opinions to their name. They don't conduct evidentiary hearings on a regular basis. And they file notices of appearance. Well, some of them are handling hearings now. And if you're handling hearings, you need to be very, very cautious. And why do I say that? Because when I sit in the back of a courtroom and I'm watching lawyers litigate at hearings, I see some recurring challenges. And those challenges are that you have non-litigating lawyers at hearings that are evidentiary in nature, and they ain't got none, right? They have no evidence. They have no witnesses to call. They have no documents to introduce, or if they do have documents, they don't have a proper method or procedure for getting those documents introduced into evidence. They don't know how to handle a hearsay objection. They don't know what a records custodian affidavit is. So be very, very cautious, right? Because our rules of competence require us to be able to handle a particular matter or to develop the skill set such that we're competent to handle the matter. So if you're handling hearings, be mindful that everything except an 845 UMC or ex parte is an evidentiary matter, right? And you actually need stuff to put in front of a judge from which he or she can make findings of fact and conclusions of law. Are you bringing a court reporter? I can't tell you how many lawyers I see go to hearings and they don't have a court reporter. There's only one reason not to have a court reporter there, and most non-litigating probate lawyers don't know why you would not want a court reporter there. So another thing that we're seeing from probate lawyers is, and look, we represent a decent amount of probate lawyers, right? When probate lawyers have a fee matter, when they think they're going to get sued, we're flattered that they think of us, that they call us, right? When the estate of the probate of the trust gets messy, they ask us to step in as co-counsel. We work a lot alongside attorneys as co-counsel, where we only handle the litigation or the controversy, whatever the specific issue is, and they handle everything else. But we see that you have a lot of probate lawyers filing a response to a petition, like a petition to revoke or something. And so I'm going to talk about affirmative defenses and waiver in a minute, but you should, if there's a motion that's been filed, if there's a petition, you should make sure that the petition is answered and that the motion is responded to. So ask yourself, did you file a response so that the appellate record is clear in your client's position? Don't just go in and argue and talk, even with a court reporter. You need something in the record. Why? Because if there's an appeal of that matter, one of the time-consuming tasks isn't just writing the initial brief or preparing a response or reply. It's assembling the record. What was done at the trial court, in addition to court-filed documents that the appellate court is going to review or consider? What did the trial court consider, and what should the appellate court look to? You need your clear response, your clear statement, your clear legal position in writing on the record, because you can't raise an issue on appeal that you didn't raise at the lower tribunal. Another issue that I see is that lawyers are constantly going in without evidence and they're arguing. And they think that certainly if the trial judge, the learned probate judge, just hears from me, certainly he or she will understand my client's position and I shall prevail. This couldn't be further from the truth, right? Oral argument of counsel is never evidence, right? Never, ever, ever. And there's cases that say that consistently, including the Smith case, right? Facts are facts. You need facts, and you need to know how to get facts into evidence. There's also exclusionary principles of evidence, which one should be familiar with in case the other side tries to get documents or testimony or hearsay or other things into evidence improperly, or quite frankly just doesn't have any evidence. So did you get all your arguments in? Was everything set forth in the record? Is it clear? Was there a writing? If you're answering a petition to revoke, I see that a lot. Probate lawyers who are administering an estate, somebody comes in, maybe a disgruntled heir or somebody who was cut out of a will, and that person files a petition to revoke probate, set aside the will, and the probate lawyer goes ahead and answers the complaint for the PR or maybe a beneficiary. And what you need to be careful about in that situation is your defenses, and including your affirmative defenses. You need to know what to assert, because if you don't assert them, those are waived. Let's move on and let's talk about a few other rules. Rule 4-1.2, objectives and scope of representation. Now, I guess the first thing to say is you should have a written contract with every client, right? You should have a legal services contract that sets out not only your rates and how much you're going to get for a retainer or an initial fee, but what you're going to do and what you're not going to do. So the scope of representation can actually be limited, and we try to do that so we're clear. So if you're representing a beneficiary and you're only representing that beneficiary as it relates to his or her inheritance, you should say that. You might also inquire whether that beneficiary has any creditor claims and whether any statements of claim need to be filed. That, to me, is an entirely separate issue, and one that you should speak to your client about, right? Because many times clients come to you when they come because they're going to inherit something, and then you start to talk to them and you realize, oh my God, they have a contract claim. They were a third-party beneficiary of a marital settlement agreement, and the insurance that was supposed to be in place for this client wasn't. And so now you have a claim. Or they're a direct a party to a contract from a business relationship, or to a marital settlement agreement. And the deceased person was supposed to do something and they didn't. And so now you have a contract claim, and you've got to file that as a creditor. So know what you're representing. You can limit your scope on what you're doing for a client, and you should spell it out in the legal services contract. Our practice is, many times clients will hire us for one particular issue, and they ask us if we can do something more or do something else. And we execute a simple 1 or 2 sentence amendment to the legal services contract that reconfirms the contract that we signed, that attaches it as an exhibit, and also that says we're now going to provide services for this new matter, and we try to define or at least list the new matter. And then on our billing system, we try to track different matters for our particular client. You can also enter a limited appearance in probate matters, right? That's a distinct difference from civil and trial work. In the probate world, you can come in and file a special limited appearance without a court order and say, I'm only going to handle, fill in the blank, statement of claim, petition to revoke probate, motion, blah, blah, blah. And then when you're done, you don't have to file a motion to withdraw or motion to substitute counsel. You just file a notice that your work is complete. And when your work is done, you should be either getting some type of an order that says you're permitted to withdraw, or there's been a substitution of counsel and you don't have any further obligations and things like that. And we're going to talk about communication in a little while, but this is serious stuff, and we want to do it correctly, or try to do it as correctly as we can. And I always take the position it's better talking to clients about it and explaining this to them and setting everything in writing, because memories fade, people forget, and we all know that people get convenient amnesia, and that doesn't help anybody, right? Having a written record of it helps everybody. It provides us all with certainty. Rule 4-1.3 is one of diligence. A lawyer shall act with reasonable diligence and promptness in representing a client, right? So Florida has long held that an attorney may be held liable for damages incurred by a client based on the attorney's failure to act with a reasonable degree of care, skill, and dispatch. This does not mean, however, that an attorney acts as an insurer of the outcome of the case. Very comforting language for us attorneys, but I got to tell you, that language ends right there. Yes, we're not an insurer, but we're still held to very high standards, right? But good faith tactical decisions or decisions made on a fairly debatable point of law are generally not actionable under this concept of judgmental immunity. If you're interested in anything about professional negligence or legal malpractice, you need to check out this doctrine of judgmental immunity. It's cited often. It's often cited as the basis for a motion for summary judgment. It is sometimes misunderstood or misapplied, but it is nevertheless a very important issue. It does not stand for the proposition that anything you do in good faith is not actionable. It does not stand for the proposition that if you're well-intentioned, you can't be sued for malpractice. What about the concept of negligent will drafting? This, I gotta believe, causes angst among at least some members of the probate bar, right? And so you had this 2000 case from Florida's 4th DCA, the Babcock v. Malone case, where these people who would have inherited from an uncle don't, because uncle didn't live long enough to sign a will or a new will. And so these would-be inheritors, I think they're nieces and nephews, they end up suing the uncle's lawyer for not preparing the will, I guess, expedient enough or fast enough, right? And it's clear. The uncle said, put these folks in the will, make them beneficiaries. The will wasn't, I guess, prepared fast enough, arguably, but uncle never signed it, right? And so this Babcock case upheld the dismissal of the complaint, and the order from the trial court was affirmed, and it cited this Espinoza case. And the Espinoza case is cited extensively in all the Florida malpractice cases, right? An attorney's liability for negligence in the performance of his or her professional duties is limited to clients with whom the attorney shares privity of contract. And so many times you see 2 recurring issues or 3 recurring issues as far as defenses go for legal malpractice. One is standing. You don't have standing to sue me. You're not a client, right? 2 is statute of limitations. You didn't file it within 2 years when you should have, when the cause of action accrued, right? And the third one is this judgmental immunity, which is this, case law created doctrine, right? But we know that a intended third-party beneficiary who is not a client of a lawyer may maintain an action for malpractice if they were in privity, right? And privity is a word of art derived from the common law. It's used to describe the relationship of persons who are parties to a contract, right? So many times when we read contracts, we can see that there are intended third-party beneficiaries. Florida courts have struggled with that issue in the context of will drafting or alleged negligent will drafting, okay? But the Espinoza case clearly stands for a very well-understood proposition that if you're going to bring a legal malpractice action, the plaintiff must either be in privity with the attorney, where you have a direct obligation, or alternatively, you must be an intended third-party beneficiary. So the intended third-party beneficiary is sometimes referred to as the privity exception, right? And Espinoza, they talked specifically about a will drafting exception to the strict privity requirement. And it's a bit odd, right? Where you can demonstrate that the apparent intent of the client in engaging the services of the lawyer was to benefit a third party, you can fall within that exception. And the cases are all over the place on this concept, right? So we see that a limited exception to the privity requirement in the area of will drafting allows an intended beneficiary to file a malpractice claim for losses resulting from a lawyer's actions or inactions where it was the apparent intent of the client to benefit that third party. And so you see courts in their appellate decisions talking about the prior will. And there's a body of case law in Florida that says, if you were not in the prior will and you were going to be in the new will, but the new will wasn't signed, you're not in privity with the lawyer, the dead client's lawyer, and you're not an intended third-party beneficiary. That, I think, is eroding. That concept of look at the prior will, are you in there? If the answer is yes, you can maintain a malpractice action. If you can't, if you're not, no. I think that's eroding. But as late as 2012, Florida appellate courts are only granting standing to those intended bennies who are in the will, the prior existing will. Never mind that the decedent asked you to do, and which you, never mind that the decedent asked you to do the will, you promised to do the will, and you're probably even paid to do that. All that matters is what the prior will says, the one which the decedent wants changed. It is a body of law throughout Florida that I think is changing and is going to change. And one place it's changed, I think, is in the gratuitous transfer circumstance, where you're outside the will drafting. So you should read the Dingle case, right? And it talks about third-party beneficiaries. The Dingle case was a case where there was a deed prepared for a grantee at the request of the grantor, and evidently the power of attorney which permitted the grantor to convey the real estate did not permit the conveyance, and so the grantor, the individual who was actually conveying it on behalf of evidently a non-Florida entity, a corporation that owned the real property, dies, and so the spouse files suit and says, hey, that deed's invalid, it was improper, and so what happens? The original grantees who received the conveyance sue the decedent's lawyer. That's the Dingle case that seems to be expanding this third-party beneficiary concept, although some of you would probably say it makes perfect sense. If I hire a lawyer to prepare a deed for you, I want to leave a piece of property to you, and my lawyer botches it, you, the intended grantee, to me is clearly a beneficiary of my contract with my lawyer, right? The lawyer is being hired to benefit not only the client, but the intended grantee. What about time frames in meeting or exceeding client expectations or returning phone calls? What's the most common complaint about lawyers? One of the most common complaints about lawyers that I read is that I didn't know what was going on. My lawyer never talked to me. He was never there when I called her. I wasn't told what I was doing. And so what you see is you see good conscientious attorneys sending lots of communications, and now increasingly by email rather than U.S. mail, but constantly updating clients, constantly sending copies of court file documents to clients, and inserting language such as, if you have any questions, let me know, or I presume you understand the content of this. Please instruct me in writing if you feel otherwise. And that leads us to the duty of communication, right? Rule 4-1.4, communication. We have a duty to inform clients of what's going on, right? And we have to have a duty under certain circumstances to promptly inform the client about certain things. And we certainly have a duty to explain things to a client. So with that said, let's talk about settlement agreements and settlements, right? Because you probate lawyers, you estate lawyers, you're involved in family disputes all the time. And in fact, many times you're not only on the front lines, but you can tell us who the troublemaker is going to be. You know, when mom dies, that little Johnny's going to file a petition to revoke probate, or Johnny's going to sue his sister or his brother. You know who the rabble rouser is, who the problem child is. You're the one who's dealing with the client and the second or third spouse and the adult children from a prior marriage or relationship who don't get along and hate each other, and they view themselves as financial adversaries and foes. So we all get ordered to mediate prior to going to trial, and increasingly you probate lawyers and estate lawyers want to mediate matters. I had a call 2 weeks ago I had just sued somebody, and the lawyer said, "Do you want to mediate? Do you want to talk about this?" And I said, "No, I want you to answer my complaint. You have 14 days." There is a custom that everyone's mediating, and mediation, truth be told, is an amazingly effective way to resolve most disputes in the probate context or the family dispute context. And so we see settlements and settlement agreements all the time. And so you have to ask yourself, does the client know what he or she is giving up? The analysis that I try to do, or the information that I try to convey to a client is, look, I'm not going to let you do anything foolish, and I'm not going to let you act foolishly. I'm not going to tell you we have to try a case because I want to try the case and I think we can win if you don't want to have it tried. There may be financial or non-financial reasons why you don't want to go to trial. You just want to resolve this. I get that. I'm not going to tell you to settle, if I don't think it's in your best interest. But that should be a determination that the client makes, right? So what's our role? Well, we should let the client know what they're giving up, right? If you're settling for 22% of the estate instead of 75% of the estate, wow, you're giving up over half, right? Okay, so what does that mean and what does that translate to? Well, if there's $4 million in the estate, or there's a house in gold bars and artwork and this and that, and you've had them appraised, you can quantify that for the client. So give them a snapshot, give them a black and white that says, if you settle, you're going to get X. If you don't settle and you prevail, you're going to get Y. And you might also look at it in the form of, well, what's your best day in court and your worst day in court? Well, your best day in court in most of our estate and probate matters is you win on everything and you get your attorney's fees paid for from the other side or from the estate or from some source like a trust, right? And maybe you get interest, and that's all great. But what's your worst day in court? Well, you lose, and you not only have to pay me, you've got to pay the other side's attorney's fees and costs, because we've got fee shifting statutes, right? And there's a risk out there. And the X factor, as I like to call it, is the attorney's fees, right? Because courts have a great discretion to award fees and costs in under any number of statutes in the probate or trust context. The one exception, I think, would be 733-106, where somebody who does not inherit from the estate, right, is not a Benny, is not a Devizee, zero, zip, does not inherit, files a petition to revoke probate, files a lawsuit, and they lose, right? 733-106 says, in a recent case from the West Coast in Florida, confirmed that while fees normally could be assessed against that losing party, the extent of that liability is their inheritance. And if you got cut out of a will, you don't have any inheritance to satisfy the attorney's fees and cost judgment. So it's almost like riskless litigation to somebody who got disinherited, because there's no personal liability to that disinherited Benny or disinherited person who loses a will contest case. The exception, of course, would be if they could be assessed with fees or costs as a sanction, or under the Bitterman Doctrine, or under 57-105. So don't dump a settlement agreement in the lap of a client. Write an email that says, hey, here you go, let me know what you want me to do. Our rules require us to tell you a little bit more and try to advise you about the pros and cons of that offer. If you want to talk about risk and reward and understanding whether an offer or potential settlement is good or bad, and whether a client's weighed it or not, weighed it properly or not, take a look at this Sauer case, another heartburn case. It involves the issue of, was there a failure to advise a client of the risks of not accepting a settlement proposal, right? And the client, in the opinion from the appellate court, just said, everything lawyers don't want to hear, and the client said, my lawyer said this, my lawyer said that, and blah, 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 blah. and it was very damning testimony, and you can judge for yourself whether it was credible or believable or not, right? But when things go south for lawyers, things can go really south, right? Clients get disgruntled, and what do? They say you did a lousy job, and you never kept me informed, and you never told me about that risk. You didn't tell me that I could get assessed with fees. You didn't tell me that if I didn't take that settlement offer that I could lose, get nothing, I have to pay the other side. Put everything in writing, and put it in there repeatedly. You know, we need to be careful about clients who also sign a settlement agreement and then get buyer's remorse. Read the Pierce case about that. Courts, or at least appellate courts, are not permitting them to get out of a settlement agreement that was signed, particularly if it was at mediation and they were represented by counsel. Are you settling matters orally on the record in the courtroom without a written agreement? I've seen lawyers do that. Sometimes you're under a time constraint, and that's in the best interest of the client. But read the Richardson case, because it's not the best way to get a deal done. Read the Sugar case. Read the Sugar case for later discovered assets, right? You have a case where parties are litigating a trust or an estate, and one party says, look, I'll take X dollars and I'm out of here. And so you come to a deal, it's a settlement agreement, the court approves it, blah, blah, blah. And then what happens a month or 2 or 3 months later? You find some gold bars or bank accounts or assets, and the person that took the X dollars comes back and says, hold on, no meeting of the minds. Had I known there were these other assets, I would have never taken X dollars. I want to get out of the settlement agreement. The Sugar case says generally, look, you can't do that unless there's some type of fraud. Settlement agreements are and mediations are actually encouraged in the state of Florida. And look, if you got a benefit from the settlement, you resolved further litigation, and there comes risk. There comes risk with anything, right? You're getting a bird in the hand and you're giving up potential stuff. So what's your takeaway from this is you may or may not want to make a condition of your settlement agreement that the estate only has certain assets. You may or may not want to have a condition that says if there are later discovered assets, they'll be shared a certain way. Or you may want to take a different approach that says, we're not making any representations, and everybody has conducted discovery, and they don't need to conduct any more discovery, and there are other non-financial advantages to resolving this matter by a settlement agreement, and I'm taking X. So rejected settlement offers and proposals for settlement. Read the air turbine tech case. That was the big case we discussed at the very, very beginning. The issue in that case was actually whether a provision in a contract that called for the payment of legal costs included attorney's fees. And the answer in Florida is no. Costs are costs. They're quite different and distinct from attorney's fees. And legal costs don't involve attorney's fees. So if you have a prevailing party provision in a contract, a prenup, or your legal services contract, what you should have is you should have language that says, if that's your intent, that the prevailing party shall be entitled to attorney's fees and costs. Don't use some mumbo jumbo like legal costs. Costs are costs. They're different than attorney's fees in Florida. Judge Brown knew that. The Fourth knew that. Judge Mara knew that. Interestingly, the federal appellate court evidently did not understand that. But nonetheless, okay, Rule 4-1.5, fees and legal costs for services. We're always citing that and citing the criteria for a reasonable fee when we have fee petitions and when we have hearings on fees, and we know that we cannot charge an excessive fee. Are each of you having your client sign a legal service contract? You should. You should not only list your rates and what your retainer is, but you should get permission to be paid from the retainer or any deposits when services are rendered. There's a great 4th District Court of Appeal case out there whose citation I forget that says giving a client 30 days to object to your invoices and fees and entries is reasonable. And so you might insert language like that into your legal services contract. What about a charging lien? Do you understand the lien on one's files and a charging lien? Here at P.L.L.C. Hauser, we like charging liens. We litigate charging liens, and we include charging liens in all our legal services contracts. And there's particular aspects about them, such as what you can do with them and where you can file them, that are important to have in your legal services contract. And it should be in writing, right? A charging lien is different than a lien on files, so you be mindful of that. At P.L.L.C. Hauser, we are going to be offering a 1-hour CLE just on charging liens. We expect to do that in the first quarter of 2017. If you'd like to attend that, it's free of charge. You can email Amanda at phflorida.com, and we'd love to have you join us. Sorry. So the slide in front of you, there's 9 cases. If you read those 9 cases, you'll learn everything you need to know about charging liens in Florida. Rule 4-1.8, conflict of interest, prohibited and other transactions. A couple of the issues that we see on a recurring basis is where you folks have a client, a probate lawyer or an estate lawyer, or a maybe you have a little elder law practice or a guardianship practice, but somebody else is paying your client's bills. And so here's a couple of issues that come up that you need to deal with. One is your client should consent to that in writing, right? And then the second thing is who do you give your invoices to? You clearly give them to your client, but what about the person paying for the legal services? Do you give them invoices? Do you give them unredacted invoices? And is that a waiver of the attorney-client privilege? You've got to be very, very careful about that. Is it a pain? Yes. Is it tedious? Yes. Should you get it right? Most certainly. Rule 4-1.6, confidentiality of information. The attorney-client privilege is an evidentiary issue that is distinct and different from our very broad duty of confidentiality. Confidentiality means I can't talk about my client's stuff, okay? I can't do that, and it's improper to do that. And so what happens with estate planning attorneys? And so you see the rule in front of you, 4-1.6, you see when a lawyer must reveal information and when information may be revealed. But, I mean, what some estate planning attorneys are doing is they're turning over files and documents without a subpoena to non-clients. I mean, we see this all the time and scratch our heads, where the adult child who is not a POA, who has no fiduciary role, is not the guardian for a mom or a dad, calls up mom or dad's estate planning lawyer and says, send me my dad's documents. Okay, I'll send them to you right now. I'll FedEx them to you and I'll send them by email. You should not be doing that. Those are your client's documents. And be mindful that adult children from a prior relationship probably don't get along with mom or dad's second or third or most current spouse. I want to thank every probate and estate planning lawyer who's still creating not necessarily marital trusts, but trusts that have the surviving spouse, the second or third or most current spouse as a lifetime Benny, and putting the kids, the adult children from the prior or first relationship in as the remainder beneficiaries. I owe you a debt of gratitude. Those are probably one of the most litigious or litigated issues or subjects in South Florida. Keep on doing it. We appreciate the business. Why you would put a second or third spouse in a trust or a financial stew with adult children of the client from a prior marriage is beyond me. There's other ways to have both of them benefit from money and wealth. And there's effective use of life insurance, and there's effective use of outright gifts. But I'm not sure that a trust is the most appropriate under those circumstances. Recent Florida cases involving ethical issues. We kind of get shortchanged here, gang. Read the McCormick case. You see the citation in front of you. You should certainly read the McCormick case. If you are one of these lawyers who drafts yourself into the documents and names yourself as trustee or PR, and if you're going to administer trusts and estates, particularly if they have unique assets like real estate or closely held business interests, the McCormick case was out of Miami. It's a third DCA case. It involves issues of disclosure and non-disclosure, compensation and fees, and the handling of some out-of-state real estate. And there's the citation. Recent non-Florida cases, we should kind of get shortchanged here on the hour as well. Here are some most recent ethical and legal malpractice cases and issues from across the country. And you'll see there's a little description about each of the issues or sub-issues that are listed right after that. Estate planning and probate malpractice is our last topic for today. Unfortunately, I've got to go through that very, very quickly, and it probably has the most slides. So what I would say is, we've got a 2.5-hour CLE free webinar on this particular topic that you can watch or listen to for free. You can email Amanda and you'll get a link that'll allow you to attend that webinar at your convenience. I think the ethics credits are 2.5 hours and they're good, I think, for 6 months. So they're probably good through the end of June or July of 2017. So let's motor through this and then we'll call it a day. Legal malpractice involves an attorney's employment, and the attorney was employed by the client or somebody, the plaintiff, was in privity with the client. Of course, the exception is somebody who was an intended third-party beneficiary, and then we can debate and litigate over of what, was it the will or was it the contract for legal services? There was a neglect of a duty, and of course, proximate cause and damages. Gotta have the damages. Don't forget the damages. I can't tell you how many appellate court decisions I read that say damages weren't proven. Causation, look, in the litigation context, you generally have to demonstrate that you would have won but for the negligence. Defenses, God, very, very important, so important. We talked about some of them earlier, like the SOL, no attorney-client relationship, no privity, a settlement. An interesting issue arises if your client settles the underlying dispute, and then comes back and sues you, and you're kind of standing there saying, you resolved this voluntarily. You can't sue me for malpractice. You abandoned that claim. You made the decision to go down a different path. You settled the damn case. You shouldn't have settled the case. You can't assign legal malpractice claims. And then an interesting issue comes up is if you're discharged, right? If you quit or you're fired, is there proximate cause? And then the whole doctrine of judgmental immunity, right? The Crosby case, right? Really, really important. And it's explored by other appellate courts. You see the Haysfield case, you see the Inlet Condo case, and then the Inlet Condo case is actually a federal opinion. You can read that, and also Air Turbine Tech that we spoke about earlier, that discusses judgmental immunity to a great degree. You could write a Florida Bar Journal article just on that topic alone. Potential exposure, best practices, man, keep everything in writing. You should be updating your clients on a regular basis. You should be sending all court file documents to them. You should be sending all offers and counter offers to them. You should be informing them that if they're involved in litigation, that because of the fee shifting statutes in Florida, that they may be responsible for paying the other side's fees if they lose, and their costs, and attorney's fees are different than costs. If you're a litigator, like my law partner, Rob Hauser, there he is arguing in front of Florida's Supreme Court earlier this year. If you're a litigator, that's great. If you're not a litigator, you got to ask yourself whether you want to walk up on Dixie Highway into the courtroom and attend an evidentiary hearing, right? Because we don't want to end up a defendant. So you'll get an hour for this session, an hour of general or ethics. The reference number of the course number is 1608-415-N as in Nancy. If you have any questions, my law partner, Rob, or I would be pleased to speak with you about any appellate issues, any trial issues, any litigious matters or disputes involving wills, trusts, estates, or guardianships. Rob also has a number of years of experience as a commercial litigator, a lot of business litigation, contract litigation. It'd be a pleasure to work with you on any of those numbers, any number of those matters. And then please look for future webinars that we're going to have throughout the year. Our goal is to offer one free of charge every month to Florida bar members, where you'll get at least an hour. And look for that CLE on charging liens that would like to bring to you in the first quarter of 2017. It's a very, very important topic that is often misunderstood by lawyers, particularly non-litigators. My name is John P.L.L.C. I'm a trial attorney with P.L.L.C. Hauser in downtown West Palm Beach. After February 1st, come on by and visit our brand new office at our building on South Olive Avenue, 415 South Olive Avenue. There's parking in the back. Come on in, say hello, see the new digs. Our contractors are in there as we bring you this webinar, and we're looking forward to the new home of P.L.L.C. Hauser. We'd love to have you stop by. Don't forget to attend the P.L.L.C. Pour, February 24th, 2017. It is a charitable event. It's an amazing event with some incredible wines, and 100% of the ticket proceeds go to the Legal Aid Society of the Palm Beaches. Thank you for listening. This concludes our webinar on this topic.